By now, you should have a good feeling for what an agent does when it comes to fields of underwriting. You are expected to protect your insurer, who is your principal, and you're also expected to complete the application while adhering to the rules put forth by the state and your insurance company. The decision whether to accept an initial premium payment is completely up to an agent. You must know the concepts behind the initial premium, the receipts that must be provided, and how your decisions can affect issuance of the policy. Remember that client information is considered protected both by the state and the federal government. This applies to more than just health and medical information. It also pertains to personally identifying information, financial data, communications, and more. HIPAA and other mandates ensure protected information is handled legally. Insurance companies and agents are required to provide certain disclosures to applicants before the completion of the sale. These include privacy notices, notice of information practices, and other documents. The field agent is usually the person who furnishes these items to the client, and failure to do so is considered a violation of law. We looked deeply into investigative consumer reports, like those from the Medical Information Bureau. We also covered the Fair Credit Reporting Act and HIPAA's privacy requirements. When selling and then delivering a policy to the client, agents should discuss the information practices used by their insurance company with the client. Most people have never heard of the MIB, and while they have passing knowledge of credit, they might not understand why insurance companies use it as an underwriting tool. Finally, we studied the replacement of a policy and its associated concerns. Replacement must be in the best interest of the client. Unnecessary replacement of a policy can land both the agent and the carrier in hot water. There are reasons to replace a policy, but there are also many reasons why a policy should not be replaced. Our next section of the lesson will look at contract law. There are 4 elements to a valid and legally enforceable insurance contract that need to be studied and retained. We'll also take a look at the issue of minors entering into a contract. A good nuts and bolts knowledge of contracts and contract law is helpful in the field and is necessary for preparing for the insurance exam. Insurance policies have some distinct and unique contractual elements and terms that are important. We're going to discuss how an insurance policy is a unilateral contract, which is a contract where only one party makes an enforceable promise. The insurance carrier makes a promise to pay a covered loss, while the insured only has to meet a few conditions, like paying the premium and reporting a loss. There are other terms you need to know that aren't seen in many other places as well. The lesson will finish with a conversation about statements applicants make on insurance applications. As mentioned earlier, there are genuine mistakes made on applications, such as if an applicant misstated a particular date. And then there are much more serious errors, including material misrepresentations and fraud.